Hey, what's going on, everybody? So we're back. This is the second video in the series, which talks about how to get rid of a judgment. And thinking back in hindsight, I may actually change the title to these two videos to something like how to escape a judgment against you, right? So essentially, these two videos are going to give you information on how you can get rid of judgments against you. You might be in a situation where there was a judgment already against you. You might be in a situation where you could potentially lose a case and you may be looking at a judgment and you need to know how you're going to deal with that. This information is for you. Or maybe you just have a friend or family member who's in that situation and they need some type of help, some type of guidance, right? So again, leave your questions and comments below and let me know if you think there's a better title for this video. But right now, I kind of want to go with how to escape court judgments because it just seems like it's a little bit more racy and it would get a little bit more attention. But let me know if you got a better title for these two videos, right? So again, if you don't know, I'm here to tell you I'm not a lawyer. I don't pretend to be a lawyer. I'm just some guy on the internet reading information, right? So take everything I say with a grain of salt. And basically, if you're representing yourself, then you need to research this information well, or you need to just go out and hire a lawyer. And of course, if you already have a lawyer, maybe this information could be useful so that you can have an educated or an intelligent conversation with your lawyer, right? But again, just know that I'm not a lawyer. I don't have a law degree. I'm not licensed to practice law. I didn't go to law school or any of that stuff. I'm just some Joe Blow on the internet reading stuff to you, right? So basically, we looked in the last video at, I think it was Rule 59, and this time we're going to look at the Federal Rules of Civil Procedure. I'm sorry, the Federal Rules of Civil Procedure 60. And there's going to be a big difference between 59 and 60. And one of the differences is going to be the time limits, which we'll get into shortly. But basically, Rule 60, relief from a judgment or order, basically, you can get relief based on corrections on clerical mistakes, oversights, and omission. The court can correct these clerical mistakes on their own, or you can get the court to correct these clerical mistakes with a motion, right? So there's other grounds. That was just kind of the first reason to potentially get a relief from a judgment, right? And it's based on mistakes or clerical errors. Perhaps you've gone to court and you heard the judgment, you knew what the judgment was supposed to be, but when it was written down on paper, then you find out that it's totally different from what you heard it to be, right? So you can go back to court and say, hey, there was a clerical mistake, I actually won this, or hey, there was a clerical mistake, I lost, but this was supposed to be the judgment. And you can get the court to correct that. Now, I believe that the best way to do that is to get the court record. I believe federal courts typically keep tracks of all their proceedings, so you can potentially get the court record, right? And then you can review it and you can figure out if there were any mistakes made, right? So there's other grounds for relief, and basically the other grounds for relief from a final judgment or order proceeding are, again, mistakes, inadvertent surprise, or inexcusable neglect, right? Perhaps your lawyer made a mistake, or perhaps he was neglectful, or perhaps maybe the opposing party did something that was inexcusable or neglectful. And this is yet another reason for you to file a motion, go before the judge and say, Judge, look, this is not right. You got to do something about this. There's an obvious mistake here and we need to fix it, right? So then the second grounds for getting relief from a final judgment is newly discovered evidence. Maybe there was something about your court case at the time that kept you from getting information which would have helped you win the case, right? Maybe the other party was holding the information or withholding information, or maybe for whatever reason under the sun, the information just wasn't available and there was no way for you to know that the information existed, right? And then all of a sudden, 2, 3 months later, you get this new evidence that basically would have allowed you to win the case. You need to file a motion, go back to court, and basically ask the judge to give you some relief from that judgment, right? So again, I think with all of the stuff I'm reading, it's going to be on the federal level. These are the civil rules and procedures for going to federal court, right? So each state court is going to have its own proceeding, or it's going to have its own mechanisms for relief from a judgment, but essentially it's going to be modeled after the federal rules, right? I find that in the state of Illinois, a lot of these same rules apply, but I find that sometimes they're enhanced, which means that you typically have more options in the state court. That's my belief, right? It may not be the case for your state, but at any rate, if you want me to do a video on your particular state, definitely leave your questions, comments below. And of course, a donation is always going to expedite that request. But anyway, moving on. Another reason to actually get relief from a judgment is going to be fraud, right? So there's two types of fraud. Well, there could be many types of fraud, but in the context of this conversation, we're looking at two types of fraud. One is going to be intrinsic fraud, and I believe this basically means something that happened in the courtroom or in the proceeding or in the case that basically kept you from having a fair trial. It could be possibly something that the judge himself did, or it could be possibly something that the prosecutor or the opposing attorney did, right? That can be considered fraudulent. And there's also intrinsic fraud, which I believe, and correct me if I'm wrong on any of these, I definitely want to hear from you. Leave your questions and comments below. If you believe I've gotten this wrong, please correct me. I encourage correction. But intrinsic fraud, and my belief, is typically going to be something that happened outside of the courtroom or outside of the court proceeding that basically created the claim for the actual case, or that's involved in a controversy. Maybe I had a contract with you outside of court, or before we even decided to go to court, or before there was even a controversy. You and I entered into a contract, and I basically lied and basically tried to deceive you so that I can basically cheat you, right? So that's one example. Another example, it could be that there's some type of exchange where I, try to cheat you or defraud you in that exchange, so that's my belief. Definitely leave your questions, comments below, and let me know if you have a different definition for intrinsic fraud or extrinsic fraud. So fraud is one of the reasons you can go back to court and say, nah, look, judge, this dude is trying to cheat me out of my cheddar. He's trying to cheat me out of my money. And I need to have this judgment set aside because, he did X, Y, Z, which kept me from basically having a fair hearing in court, or there was a fraud on the court, or there was some type of fraud before this case even began that basically created this case. Or maybe, for example, the party, in terms of intrinsic fraud, maybe the person forged documents and created some type of claim against you by forging documents, right? So I believe that would be another example of intrinsic fraud. Now, one of the things that I think should be noted here is that I think that as we're talking now, you only have up to a year to basically claim intrinsic fraud or extrinsic fraud. But it gets a little confusing because extrinsic fraud can also be known as fraud on the court, and there's no limitation for that. And we're going to talk about the times constraints really shortly here. But moving on, another reason you can basically go back to court, file a motion, and get relief from the judgment is because the judgment is void for some particular reason, right? So if the judgment is void, you can go back to the court and you can say, hey, you know what, judge, this thing is void. We need to vacate this because we don't want the opposing party to try to act on this judgment. It's going to create a lot of damage. But at the end of the day, the judgment is void. And there could be a lot of reasons why the judgment is void, but some of the popular reasons the judgment could be void is because of jurisdiction, right? Maybe the court didn't have the proper jurisdiction to actually make the claim or make the judgment that they initially made, so on and so forth, right? So moving right along, another reason you can go back to court and basically ask the judge to give you relief from the judgment is because for whatever reason you didn't believe you I'm sorry, for whatever reason it wasn't disclosed, but basically the party was already paid, or there was always already a release or discharge, right? Which typically means in a case of some type of money controversy, you paid them, so you want to get immediate relief for the judgment. Or maybe there was a situation where you guys were fighting, you going back and forth to court, and basically after you lost, you just went ahead and just paid the person, and you want to have that put on record that the person has been paid, and you want the judge to basically relieve you of this judgment, right? Instead of waiting X amount of days or X period of time, or possibly waiting on the opposing party to acknowledge that it's paid. You don't want the opposing party to do something dirty like try to double collect on you. You go back to court and you can basically say, hey, judge, this was paid already. Please vacate this judgment. Or it could possibly be a situation where you find out late in the litigation, or after or towards the end of the litigation, that the opposing party received payment through some other means or through some other source, and you're basically somehow there's a judgment put in. You're basically just trying to get the judge to vacate the judgment because the party has already received payment or the judgment has been discharged, right? So moving on, basically another reason that justifies relief. So moving on, and this one is actually kind of tricky, but it looks like the court can give you relief from a judgment for any other reason that justifies relief, right? So it's kind of funny because all these other reasons are very specific, but number six or B6 basically says for any other reason, right? The judge can basically vacate the judgment or give you relief from the judgment for any other reason, right? So when we look at that, basically it looks like the judge can kind of do this willy-nilly and say, we're just gonna, give you relief. So this one is kind of interesting because it's a little ambiguous. And for any other reason that justifies relief, like, what is that? So actually, I'm going to get into this one a little bit later, but just know that there could be other reasons beyond what we've already read that the judge can, by law, give you relief or vacate a judgment. So just know that just because the reason is not already listed here as you see, there could be other reasons, and it's going to be situation specific to your situation on why the judge can grant relief. So I would, look at this as a hope and a prayer type of claim, right? So if you're making a claim for number 6, it could be a hope and a prayer, or it has to be something super solid. And we're going to get into that, but just know it has to be specific to your situation. And because there's some special circumstances, you can ask the judge for relief. And we're going to get into that shortly. So there are time limits, right? So whereas the previous video, we talked about Rule 59, you have basically 29 days or 28 days to basically go back to court and make one of those claims in the other video, right? So in Rule 60, basically you have a little bit more time, right? And basically I'll just read it here. It says a motion under Rule 60B must be made within a reasonable time, and for reasons 1, 2, and 3, no more than a year, right? So reasons 1, 2, and 3, mistakes, inadvertent surprise, excusable neglect, newly discovered evidence, and fraud, you have up to a year to make that those claims, any one of those claims. But remember, I believe that intrinsic fraud is not going to apply, and we're going to get to that in a second. But basically, you have up to a year to make a claim for 1, 2, and 3, right? So for 4, 5, and 6, in my opinion, there is no time limit, right? It's reasonable as it relates to your situation, right? So if a judgment is void, basically it's well known that a void judgment can be attacked at any time in any court, right? So if the judgment is void, there is no time limit. For example, if you have a judgment that's void due to subject matter jurisdiction, you can come back 20 or 30 years and basically attack that judgment or to ask the judge to vacate it because it's void, right? It was void when it was entered and it's void after, right? So yeah, just to put everything in perspective. So basically, for reasons 1, 2, and 3, you have less than a year, no more than a year. And then 4, 5, and 6, it's basically going to be within a reasonable amount of time. And that's going to be subjected to whatever the situation is, right? So that's that. So moving on, basically, other powers to grant relief. This rule does not limit the court's power to: 1, entertain an independent action to relieve a party from a judgment or order or proceeding, right? So this one basically gives you the opportunity to actually file additional claims to basically relieve yourself of the judgment, right? And this one is kind of tricky, and I'm not 100% solid on this one. So if you know this stuff and you understand it like the back of your hand, please leave your questions, comments below and educate the rest of us. But I'll get into it a little bit later when we look at probably some case law. And then there's also other claims for relief. Basically, you can be granted relief under 28 USC 1655 if you weren't properly notified of the action. And basically, if I can remember correctly, this is a federal statute that allows them to garnish your property. So for whatever reason, they are in the midst of garnishing your property, and basically you were never notified of the proceedings against you. So now you can go back to court and ask the judge to stop this because you never knew about it. And basically, from my understanding, you can potentially get relief from that, right? So now, and the final reason, basically, you can ask the judge to set aside a judgment or order because there was fraud on the court. And again, fraud on the court, in my opinion, is going to be very similar, or is going to be almost the same thing as intrinsic fraud, meaning there's something about the court proceedings, or there's something that happened within the court proceeding which basically kept you from having due process, or there was some type of fraud that was involved with the court proceedings that basically kept you from litigating or defending yourself or pursuing your case. So that is yet another reason to go before the judge and say, hey, judge, look, there was some fraud happening and I need you to vacate this judgment or basically, keep them from executing this judgment. And that's yet another reason you can ask for a relief from a judgment or order, right? So let's go ahead and get into some case law and let's look at some of the specific reasons, right? So one of the reasons for asking for a relief or judgment is that for this one section here where it says any other reason that justifies relief, right? So I'm just basically going to read to you here and it's going to be word for word verbatim. So bear with me if you can. Basically, motions under rules catch-all categories, which permits a court to reopen a judgment for any other reason that justifies relief. It's basically in the discretion of the courts, but we have held that relief under this rule is available only in extraordinary circumstances. So if you're going to go to court, you're going to ask the judge for relief from a judgment or order. You're going to ask him to stop the judgment. You're going to ask him to stop them from collecting on the order. Basically, you have to have an extraordinary circumstance, right? And it basically goes on to say, in determining whether extraordinary circumstances are present, a court must consider a wide range of factors. These may include an inappropriate case, the risk of injustice to the parties, and the risk of undermining the public's confidence in judicial process, right? So obviously this is going to be something highly specific to your case. There's no example that I could give you that's going to apply to any and all situation, but basically it has to be an extraordinary circumstances, something way outside the norm, and there may include that the case itself was inappropriate or there's a risk of injustice to the parties and the risk of undermining the public's confidence in the court, basically, right? So I actually have some additional notes. Authorizes a district court, 60B authorizes a district court to grant relief from a final judgment for 5 enumerated reasons or any other reason that justifies relief. While the catch-all reason includes few textual limitations, its context requires that it may be invoked only in extraordinary circumstances. So any other reason is basically a catch-all motion or a catch-all category where you can go to court. Not category, that's a bad word, but it's basically a catch-all or savings clause, I guess it's called, for you to go to court for any old reason, not any old reason, but any other reason, and it has to have some extraordinary circumstances. So that's that, right? I have some additional Rule 60B case law, but at this point, we're beating the dead dog with a stick. So there was another one, and basically an independent action to relieve a party from a judgment. That one was also interesting because actually it's here in Rule 60D, right? Other powers to grant relief, and basically it's entertain an independent action to relieve a party from a judgment or order proceeding, right? So you can go to court and ask the judge to allow you to execute or file a motion for independent action, or file a petition, for independent action to relieve a party from a judgment, right? So independent action to relieve a party from a judgment. Basically, this does not limit the power of the court to entertain an independent action to relieve a party from a judgment. The independent action referred to in this rule is what had been historically known simply as an independent action in equity to obtain relief from a judgment. So this is yet another clause that's going to, not a clause, but it's going to be another provision in the federal statute that's going to allow you to file a separate case in equity with hopes of getting out of the judgment. Okay, so finally, let's just look at some case law for 60D1, which basically allows you to go before a judge after a final judgment to basically file a motion and say, hey, I want to entertain an independent action to relieve me from a judgment or order or proceeding. It actually reads, entertain an independent action to relieve a party from a judgment or order or proceeding, right? So this one is a little tricky here, but basically the case law that I found goes on to say that an independent action to relieve a party of a final judgment does not limit the power of the court to entertain an independent action to relieve a party from a judgment or order. The independent action referred to in this rule is what have been historically known simply as an independent action in equity to obtain relief from a judgment. Now, when we're talking about equity, we're typically talking about injunctions and things of that nature, or cases where you're trying to get a person from to stop doing something to prevent them from doing something. That's my belief. Please correct me if I'm wrong below. Leave your questions and comments, right? But it goes on to say an independent action is available only to prevent a grave miscarriage of justice. So if you're going to go back before the judge to ask him to stop that order, it looks like you have to show that there's going to be some grave miscarriage of justice, as it reads here. And then it also goes on to say available when enforcement of a judgment is manifestly unconscionable. Basically, relief is unconscionable. And basically, that's saying that the judgment itself is going to do something that's just totally foul or just totally evil. And you're going before the judge and say, hey, yeah, they won, but do you really want to execute this judgment? Do you want to allow them to execute this judgment? Because it's basically going to be evil, right? And everyone knows it's well established that courts are not here to promote fraud and injustice. So there could be a situation where they won, right? But what they're doing is so bad, it's so evil, or it's just so unthinkable that it has to be stopped. And this is yet another argument that you want to make to the court or the judge if you're going back to ask him to put aside this judgment, in my opinion, right? So, and then it just goes on to say that relief pursuant to the independent action is available only in cases of unusual and exceptional circumstances. So it's kind of funny because it kind of sounds like it's almost the same as any other reason in which you have to have, what does it say here? What does it say? Where it says basically there has to be an extraordinary circumstance. It's almost the same wording. So why, and this one says exceptional circumstances, is almost the same wording. And it would make me think that there's no reason that both of these two provisions should exist. But I'm not a legal scholar, and I have to believe the people who wrote the statute wants you to have both number 6, any other reason, right? And D1, entertain an independent action to relieve a party of a judgment or order. I guess one could be that in the first situation, any other reason, the judge is actually going to basically make a decision right here and right now, right? And then the other one, D1, allows for an additional lawsuit to be filed, which would give you probably more opportunity to present a case on why this situation is extraordinary or exceptional. So I guess that's the reason that there are two provisions in one, just thinking out loud, the judge is going to make an immediate decision, and then in the other, you're filing a new case or an additional case and then you get a chance to present uh, more evidence, and that could basically be another case which would basically drag on for another 2-3 years, or God knows however long it drags, and you get the opportunity to basically put on a new case, right? So, but in either situation, the reason is going to have to be extraordinary or a exceptional. Is that what it says? Let's see here. Yeah, in exceptional circumstances. So that's pretty much it for this video series. Definitely leave your questions, comments below. And you know what? If you're having any particular issues, legal problems, I want to hear from you. Definitely leave your questions, comments below, but also reach out to me. I love to talk to you about your specific legal issue or problem. And when you reach out to me, do know that, again, I'm not a lawyer, and I'm definitely not, licensed to give any legal advice. But it's always good to talk to people. So definitely leave your questions, comments below, and let me know what you think of this video. Please like, share, and subscribe. And thanks for watching.